All right, welcome to this explainer where we're confronting the absolute criticality of the client relationship model. We are dealing with a framework where precision is mandatory and assumptions, well, they're fatal. This isn't just some abstract theory we're talking about. This is the regulatory bedrock of your entire practice. So let's get right into it. Just think about this for a second. If I'm wrong here, CIRO will never trust me with clients. That is the exact attitude you need to adopt starting right now. We are talking about non-negotiable regulatory obligations where a single misstep can literally cost you your career. You have to treat every interaction, every form, and every recommendation as if your license depends on it. Because frankly, it does. Moving right along into the pillars of client trust, non-negotiable transparency. We first have to conquer the absolute foundation of all client interactions. And that foundation rests on 4 unyielding pillars of the client relationship model. These 4 pillars govern absolutely everything you do. Notice the strict sequence here. It all kicks off with the Relationship Disclosure Document, or the RDI. You cannot just hand this over casually after a few trades. This has to be delivered at account opening before a single transaction ever takes place. It lays out your fees, your firm's regulation, and your exact duty to the client. Which builds directly into our second pillar. When you're dealing with conflicts of interest, the client-focused reforms mandate a very rigid progression. First, you have to identify the potential or actual conflict, say proprietary funds paying higher commissions. Next, you must disclose it in writing before any transaction happens. And here is the crucial part. You must either manage it in the client's best interest or avoid it entirely. You cannot merely say, well, I disclosed it, time to proceed, if that conflict harms the client. The rules are absolute. All right, let's talk about client classification and exemptions, the rigid boundaries. Failing to understand exactly who you are dealing with here triggers massive regulatory breaches. In this regulatory landscape, every individual defaults to retail. That classification carries the highest level of protection and demands full suitability on every single trade. Institutions, they get a pass. But pay close attention to this massive exam trap. Accredited investors gain access to exempt markets, but they are still technically retail clients bound by strict suitability rules. Never make the assumption that an accredited investor gets an institutional free pass. So how do we actually classify someone as an accredited investor? There are 3 specific tests, starting with the financial asset test. A client needs $1 million in financial assets, meaning cash, stocks, or bonds, strictly excluding their primary residence. Alternatively, we have the net income test. Here, they have to earn $200,000 annually or $300,000 combined with a spouse. And the regulatory catch you need to remember? They must have met this threshold for 2 consecutive years with a reasonable expectation that it's going to continue. Finally, the net asset test sets the bar at $5 million in total net assets. Now, here is the huge distinction from the first test we talked about. This $5 million calculation critically can include the primary residence. It's a high bar, sure, but it's very accessible for wealthy homeowners. Let's put this into practice with a quick scenario. Say a pension fund with $500 million in assets wants to buy a large bond position. How are they classified? When you're faced with this, you have to immediately recognize this entity as institutional, which automatically qualifies them for a suitability exemption due to their assumed sophistication. You definitely do not need to walk a $500 million fund through a retail risk tolerance questionnaire. And that brings us to the most heavily tested, high-stakes concept in this whole module, the ultimate suitability test, navigating KYC and KYP. This is where Know Your Client meets Know Your Product. To truly master suitability, you have to perfectly distinguish between 2 totally different forces. Risk tolerance is the client's psychological state, their emotional willingness to accept market swings. Risk capacity, on the other hand, is their mathematical, financial reality based on hard data from the new account application form, like their income, their assets, and their liabilities. So what happens when these 2 collide? Enter the lower of rule. This is a mandatory regulatory requirement stating that an investment recommendation must be based on the lower of a client's risk tolerance and risk capacity. This isn't a suggestion, it is absolute law. A wealthy client who can mathematically afford to lose money but is psychologically terrified gets a conservative portfolio, and a bold, highly aggressive client who is financially fragile, they get the exact same conservative treatment. The lower factor always dictates the recommendation. Furthermore, the client's time horizon acts as an ultimate override on all those other factors. A short-term horizon, which means anything under 3 years, demands capital preservation, period. If a client needs their funds in 2 years to buy a house, it doesn't matter if their risk tolerance is sky high, you are required to recommend capital-stable products. Now, suitability isn't just about picking the right fund. We also have to look at managing costs and third parties, protecting the client. It is our job to ensure we're safeguarding the client from external actors and systemic financial drag. Please do not fall for this classic trap. You have to know the exact legal distinction here. A trusted contact person is strictly for emergencies involving suspected financial exploitation or diminished capacity. They have absolutely zero legal authority. In sharp contrast, only a legally verified power of attorney can actually give instructions and transact on the account. If a TCP tries to call you and place a trade, you must refuse. You also have to rigorously factor in systemic costs, like the management expense ratio, because when you run the numbers over 20 years, even a tiny 1% difference brutally compounds. This effectively destroys client wealth and can render an otherwise decent product entirely unsuitable. Things like deferred sales charges that create liquidity traps or high turnover funds that trigger massive tax bills in non-registered accounts must all be heavily weighed. Which brings us to the absolute requirement for your career and your firm. The rule of documentation, your ultimate defense. Engrave this quote in your mind. If it isn't documented, it didn't happen. Every substantive interaction, every time a client's life circumstances materially change and you update a KYC factor on the NAF, and every resulting suitability reassessment, it must all be recorded as if CIRO is standing there looking over your shoulder. Mental notes simply do not exist in the eyes of regulators. And how long do you have to maintain these highly detailed client records? Exactly 7 years after an account is closed. Note that carefully. Not 7 years after a trade, but 7 years after the entire account ceases to exist. So, we've walked through the non-negotiable pillars of trust, the rigid lines of classification, and the absolute laws of suitability. Every single decision you make going forward carries real-world financial consequences for the client and immense regulatory weight for you. So I'll leave you with this provocative question to ask yourself. Are you ready to stake your entire career on a single suitability assessment? Make absolutely sure you have mastered this high-stakes gauntlet before you ever make a recommendation.